Oh, yes. Hi, how are you? This is the attorney, Arkady Frekhtman.
Hi, Mr. Frekhtman. How are you?
Oh, good, good. How are you doing? How's everything going?
We're doing pretty good. Me and my husband were sitting here together, and we just had a few questions and just wanted a little advice to which way we should move. Um, I've asked you several questions before about this case, and I know you have a lot of people that you deal with. My husband was injured December 23rd of 2022. We have a case going in Ohio, and we're in litigation. Now, the question that I have we both have for you is my husband was injured. He was plowing snow on a commercial property that he was hired to do the work, and he came in contact with a sewer cup drain cover that was concealed with snow. It was pretty broken up around the perimeter of the actual cover. Deterioration is what it was, and it was kind of sticking up. And his snowplow came into contact with it, and it brought him to a complete stop. And he ended up getting two fusion surgeries. He had a lot of stuff going on, but yeah, he had an anterior and a posterior, two different surgeries. The question that I have is the attorney that he's dealing with, we're okay with him, but there's just a lot of things that's missing that we feel his approach is it's not right. For one thing, he submitted a demand for $1.8 million before he even received my husband's economic report back. So finally, he got the economic report back, and it came back as $2,200,000. So we feel like maybe he needs to go up on the demand.
Well, let me just say, like, I'm really sorry to hear this happen. First of all, like this, that he had this injury and this accident. But yeah, I do remember. I think you even sent me a photo of the drain cover, so I have the photo. I remember how what it looks like. It does look like a pretty severe. They would almost say it's open and obvious. But if it was concealed by snow, then then he wouldn't see it.
Correct.
So that's a good case. And where is which city in Ohio? Where is the case pending?
It's in Toledo.
Toledo. Okay. And you live there as well, near Toledo in that area?
Yes, we live in Toledo.
Okay. Yeah, I mean, and I actually did look up the information for the attorney that you sent. So I looked up, and he had like one case that was kind of okay. I think it was a pretty good result, but every other case that was listed was either zero or really small, like, 5,000, 10,000, 14,000. There was only one case with a large verdict. I forget the exact amount, but it wasn't that large. It was maybe like around 1 million, but everything else was much, much less. So I'll send you the results. I think I have them in my email. I'll forward them. If you text me your email, I don't know if you texted me your email before, but if not, if you text me your email, I'll forward that to you. But yeah, but then like, so he had an anterior and a posterior fusion, and where was the fusion? What levels was it in?
So the first anterior fusion was a C5, 6, and 7, and then the posterior that he had was a C3 through a C7.
Oh wow, so that's really serious. That's really serious. Yeah. And how old is he?
He's 52.
Oh, so he's still a young guy. Wow, and he was working plowing snow. That was his job, right? He was plowing snow as part of his job.
Correct.
Okay. And how did it happen exactly? Was he like in a snow plow, or was he like walking plow, pushing a plow, or how did it happen?
No, he was actually driving his pickup truck that has the plow attached to it, and he came to contact with like I said, it was concealed with snow. It was 22 when we had a very, very bad winter storm, and he came in contact with it, and it brought him to a complete stop, and he just injured himself that way.
Oh, so he was driving like a snow plow, like a truck, right? And then it had a snow plow attached to it, and but he wasn't going. Was he going like what speed he was going right before he crashed into this sewer cover?
He was only going, what did you say, about 15? 15 miles an hour, just a regular pace, like, you would plow snow. Hmm.
Oh, okay. So like, so that's pretty slow, but because it was such a severe, because I saw the photo, it was almost like completely dislodged. There was a big hole because it was so severe. I guess his vehicle flew into that hole and it caused a severe crash.
Correct. So pretty much, the lawyer's letting us know that the defense attorney, she's really not fighting him on anything. Liability, he said, seems to be more on our side, and that was kind of determined in deposition with the defense's witness, which stated that he tried to get someone to fix the hazard. He was unable to, and he pretty much just gave up on it. He admitted that he did know the hazard was there, and he also admitted that another person had an accident there also with the same sewer drain.
Oh, so that's good. That's good. I mean, that's a good.
Yes.
That's called like an prior similar incident or other similar incidents. That's as long as it's similar, you can get that into evidence and use that as proof of negligence that something very similar happened before, especially if it was with a truck or a car, and then you knew about it, you should have fixed it, and you still didn't. So that no, that makes it a really strong case on liability. And then who are you suing exactly? Who is the defendant?
So the defendant's name is, there was a transfer of ownership 2 months before my husband's accident. So she just acquired this property. And so our next question would be, I don't know why, but they're saying that they only have 1 million coverage. Mr. Frekhtman, this is it's a strip mall, it's a plaza. It's named on the county auditor as a neighborhood shopping center, but it's actually a strip mall with almost 30, 20 something units there. And we're just having a hard time really believing that that's all the insurance that there is. Kind of like we're not being told the truth about policy limits or how many policies there may be. So, what we would like to get some advice on is, there's a close of a discovery on November the 30th on this case. We're just wondering, we haven't gotten any settlement offers as of yet, but I think they're trying to get that together. Lawyer spoke with the defense attorney and she said she wants to settle this case. She's working on getting an approval to enter to our demand, is what she said. Question I have is, in your experience with these cases, is it typical for the defense and the attorney or the insurance company to not disclose all insurance in the beginning, even when a lawsuit has been filed?
Well, no, I mean that's the thing. I mean, if it does happen that they don't disclose all of it, like for example, I was handling a case that I took over from a prior lawyer, and the prior lawyer thought that it was only 1 million in coverage, so he demanded less than 1 million. And then I stepped into the case and I found out there was 1 million, but there was 25 million excess that I couldn't. I mean, it took me a little bit of a fight to get that. I had to send them letters, and then they didn't want to give it, and then I threatened to make a motion because you're entitled to that by law. Usually, it's supposed to be automatic that they're just supposed to tell you, but they never want to tell you. Uh, and so it sounds like when you say 20 units, do you mean like 20 different stores in the shopping in a strip mall, like a restaurant or other stores, 20 different stores? So it's a pretty big strip mall.
Yep, there's like a strip mall, and there's over 20 different units, meaning yes, suites.
Suites, right? And it's pretty big. Like some are restaurants, some are like stores. Like what kind of units are there are present there?
There's different things in there. There's a restaurant, there's salons. It's just your typical strip mall with different businesses.
Oh, salons, and this is in Toledo, Ohio, right? Toledo, Ohio. Yeah. I
Correct.
mean, I don't. I
And I,
mean, it doesn't sound like it could only be 1 million coverage for the whole mall. I mean, and it happened in a public area, right? Just kind of in the parking lot. So that wouldn't be an area that's owned by any particular business. Like you're not suing, like for example, a restaurant. You're suing the whole mall, right? That OJW Investments. They're the owners of the entire mall, the entire strip mall.
There, yes,
Um,
correct. They're
so yeah,
the owners of the entire place there. Yep.
right. So it should have more, it should have more insurance than that, but I would double check. I mean, you could ask your lawyer or, if he's not or if they aren't pursuing that, you might want to maybe get a second opinion from someone else. But usually, I mean, it's really easy to do. You just send them a letter and you say, give me the primary policy, including any, and then give me the excess policy or umbrella. So I want to know all the policies involved. And then once you get that information, you have everything. But I mean, it could be a million primary, but there should be excess or umbrella for a big mall like that, with
Well,
20
the
different.
defense is stating, she's stating that that's all there is a million. But like I said, they're trying to settle, and we're just confused as to
Yeah, but they can't just
settle.
say it. See, they can't just say all there is a million. You have to get it in writing. Like, for example, they have to give you an official statement, not just from the lawyer, but from the owner. It has to be signed, and they have to say all there is a million. And I swear that there's not any, swear under penalty of perjury. There's not any excess. There's not any umbrella, any concurrent, or any other coverage other than this primary for a million. And then also you can get affidavits of search from the brokers because the brokers are the people that usually sell the insurance. So you get affidavits of search that they did a search and there is nothing else. Like you really want to, close all the possibilities. If that's all been done and it's really only a million, then you kind of will say, okay, that's all there is. But it's unlikely if it's a big mall like that. And is it big in size too? Like, I know some malls when you drive in, there's like stores here and then there's stores around the corner and it's like a pretty big, like if it's one of those, it's unlikely it's going to just be a million for the whole thing. I don't even know if that's allowed because they also require the tenants to have insurance. So each, like the restaurant probably has to have a million for what happens on their premises, but then what happens in the common area? Like what if there's a fire and every store burns down? What, they're only going to have a million total, and then they have to divide it
Correct.
20 ways. So it's a million divided by 20. It's not very much. It seems almost incredible. It seems almost like impossible.
So my next question to you would be, as far as the lawyer demanding the 1.8 million before the economic report was available, is there, how would you handle that?
Well, yeah, that doesn't make any sense either because he's demanding 1.8. Well, first of all, if there's only a million, then he's demanding 1.8. He's demanding more than there is, but he's not finding out if that's even true, whether there's a million, because there could be a million with like another 5 million or 10 million umbrella, right? But also it's premature because he's got to know the economic. Because remember, you're entitled to all of it, meaning you're entitled to pain and suffering, past and future. You're entitled to loss of enjoyment of life. Those are the non-economic. Those are probably going to be most of the damages. But then you're also entitled to the economic, which includes like lost wages as well as future medical costs. So if you had, like, say, a C3 to C7, well, then you're going to need, C2 because of adjacent segment disease, and that could be $100,000 surgery. And then what about C8, right, or down to T1, that area? On the other, the next adjacent level after C7. So then that's another like 100,000 or close to that. And then what about everything like MRIs and, physical therapy and just treatment? It's going to add up. Or 50-year-old, that could be well into that could be, like you said, two or more million. 2.2, I think you said 2,200,000. Like I had a client who was given, my economist said it was 2.7 million, and he was 57 years old and he only had a one level, an L5S1. So, it varies depending on the economist and depending on the doctors and what treatment they recommend, but it could be higher than that. So yeah, why would you demand only 1.8? That's very low. And, but to answer your question, just generally, I don't like the whole idea of, demands, because you see what they're doing. The insurance company and the defendant, they're not even telling you how much they have, but they're like, oh, let's settle this, demand something. And then once you demand a number, you could only get less than that number. They'll never give you more. So demanding 1.8, well, now they're going to try to pay less than a million. They like to pay you maybe 30%, 20% of what you demand. But then if just the economics are 2.2, but remember the economics are just one part of it, but you're entitled to everything, like all the damages, and there's different categories. So altogether it could be much greater. But also, I like to just tell them, look, first you have to get all the information. You have to know how much insurance there is. You have to know if there's excess and umbrella, like officially, like really close off all the possibilities. And once you confirm that, then you have to make, not make a demand, but tell them, okay, this case, for example, give them an opportunity, like send them a letter and say, this case, we would resolve this case for example, 5 million. You have 30 days. It's a long look, like I usually do a 15 or 20-page letter where I talk about all the medicals and all the economics, non-economics, everything in there. And then basically, look, you say at the end, it's up to you. If you want to pay the 5 million, that's fine. And if you don't, that's also fine. But it's not going to be 5 million anymore. The more time we spend preparing for trial, it might go up to 7.5 or maybe more than that, and you just keep stair stepping up the other way. That really puts the fear of God into them. They don't like that, because remember these insurance companies, they're all about protecting their money, saving money, you know. That's what really what they're all about. So that's why I like to do it that way. But not every lawyer does it that way. But that's okay. But basically, I just don't understand like it doesn't seem like there's any plan because you can't start talking settlement until you know how much insurance there is, or unless you're 100% convinced that's really, so you have to get the insurance information first, and know for sure, and then second, it doesn't make sense to demand 1.8 if just the economics are 2.2, because remember the economics are just one part of it, so it doesn't make sense, because that's way, he's like 400,000 less than just the economics. But what about the pain and suffering, the loss of enjoyment of life? And has the lawyer ever like done any kind of biography into you or your husband, into like the human story, like finding out how this has affected you? Because this is a major life-changing injury. This is like a huge surgeries that he's had.
Right. Correct. You're right. So that's where I think he's not. I don't think he's getting that part. And like I said, we're okay with our lawyer, but we're starting to get to the point where one, it's not making sense. The mistake has been made already of you asking a demand of 1.8 million, and he never disclosed that he did that. We had to find that out. He did not. He did that without our permission.
Oh, that's not good. Well, how did you find that out? Did he tell you, or how did you find that out?
Well, what happened was we hired a law firm. The law firm hired him for the case probably about 4 months ago. Well, actually, it was in January when the depositions happened, and the defense lawyers stated to the lawyer, "Get me your demand." After deposition, that day, the lawyer called us and told us that he was leaving the law firm. And my husband said, "Well, I don't want to deal with the law firm. I want to keep you. You've gotten the case this far." So my husband ended up keeping him. The law firm called, previous law was a law firm that was dealing with the case, called my husband and said, "We understand that you want to leave this firm to go with the other lawyer." And they tried to talk to my husband and keeping them. And that's when he found out that there was a demand made for 1.8. And we were totally in the dark about that. So this case is all over the place. But
Oh, I see. Yeah. So he left the one firm and he went over to a different firm. I mean, that happens. And then it's the client's choice. He could follow the lawyer, he could stay with the firm. But yeah, he shouldn't have done that. He shouldn't have made such a lowball demand, especially without knowing the insurance limits and without, knowing the economic damages. But I mean, it sounds very unlikely that it's only a million. I mean, that would be really surprised. That's very odd because like if it's 20 different businesses, what if the whole thing burns down? Like, how could each business is only gonna get like $50,000, divided a million by 20? It just doesn't make any sense. So,
we voiced our concern with him in regard to there may be more insurance And he claims that he sent over an affidavit that we failed to see. I would have thought he would have submitted it through the docket. I mean, through the you know how the case is on the
with the case.
so I can follow the case on the docket where I can see what the judge is saying, the motions, all of that. But I didn't see that being submitted through that.
So on one
But I don't even know if he's telling us the truth in regards to him sending over that paperwork asking for the affidavit, asking
Well, that's
for.
not good. I mean, yeah, you definitely want to have transparency and get all the information. But like I said, it's automatic. I mean, it's right in the preliminary conference order when you start the case. It says that the defendants to provide all insurance information. And in New York, we have it in multiple sections, like 3101F, and there's another section where they have to tell you. And if they don't tell you, I mean, you could make a motion, and the judge will just give another order. It's already in the preliminary conference order, but he could do another order and saying, look, you have to tell them. And everyone kind of knows that. And I'm sure I'm not familiar with specifics of state practice in Ohio, but I couldn't imagine it would be much different if even if it's not automatic, it's essential discovery that they're entitled to, that you're entitled to. So meaning like if you ask for it, they can't say we're not going to tell you how much insurance we have. Just like if they asked you, well, what doctor did your surgery, like one of these surgeries, you can't say, oh, I'm not going to tell you the doctor, right? They're entitled to know which doctor did your surgery. They're entitled to the operative report. Otherwise, they'll say, well, this is prejudicial. You're going to a jury trial and trying to claim, money for a surgery that you're claiming we caused, and you're not giving us the operative report, you're not giving us the doctor. Well, it's the same thing. If you're suing them, you want to know how much insurance they have. It's like a basic thing. So, you're totally entitled to that. So you just have to follow through, have them make a motion and get it from a court order and have them certify to the court and to you in an affidavit that that's all they have, that there's no excess, no umbrella. And it could also be that, there could be other companies like a holding company or someone else involved that maybe they should have sued. I don't know if it's too late. It might be too late now, right? Because it's already been, well, actually, maybe not. If it's 3 years, you're still within the 3 years, right? Because the 3 years would expire December 23rd, but you're kind of cutting it close. I don't know if Ohio is 2 years or 3 years, but like New York, we have a 3 year statute, because sometimes it gets a little complicated. You have to make sure you sue all the proper entities, because if they sued one entity, but there's some other holding company that's like the parent for the whole strip mall, they might have other coverage. Or if it happened in a place that might be the responsibility of one of the tenants, that you want to sue the tenant as well as the holding company as well as the owner. So sometimes it gets not too complicated, but by now they should have figured that out. It's been like almost 3 years. So.
Correct. So is it possible that could it be that she has a primary policy with one insurance company? Is it likely that she may have umbrella through somewhere else?
Yeah, it's very likely. I mean, that's what we had in our case that we did. We had a building in Manhattan that it was like a primary through one company, and I think it was Chubb for the excess, and the excess was 25 million. And we actually said, what's the excess? And they didn't want to tell us. And then I called the lawyer, the plaintiff's lawyer who represented the injury victim, and we tried to ask him, does he know? Because we thought he would know before we, called the defense lawyer, and he just said, I don't know, and I didn't even want to find out. I don't even care. I'm like, well, you wouldn't want to know that. I guess he didn't think the case was worth more than 1 million, So I think he was demanding like 800,000 or something, or 600,000, I think. But anyway, but then we found out, and then the lawyer started writing us ridiculous letters. The defense lawyer saying like, I'm not going to tell you because the first lawyer didn't ask, so now I don't have to tell you. I was like, what? No, you have to tell me. This is basic information. So finally, he was like, okay, yeah, you're right here. And then he told us it was 25 million. And then the case, we ended up settling it for I think 1.3 million or something like that, because it just wasn't really, the injuries weren't worth, it was like one surgery, it wasn't worth, it was like a knee injury, it wasn't worth like 25 million. But you want to still know that, but we ended up getting more than the primary, which was good. So the client was very happy. But you know what I mean? But you want to know that. And that happens in other cases too. Like I've had cases with like ceiling collapses where they keep saying a million, and then when you kind of push them, you find out yeah, there's a million, but there's also like 10 million excess, or umbrella. So you really have to just find that out. I mean, I would probably get the court involved, but I don't know, but it's just like raising like multiple red flags. So, it's ultimately your decision. You could, of course, have this lawyer finish it out, or you could maybe get a second opinion from someone else. I know some good trial attorneys that are, some of the best in Ohio. It's actually a place where there are a lot of really good lawyers. And I also have access to that verdict search. So I could go into the verdict search and search for this kind of case. Let's say where a truck hits some kind of an object, or a car accident, or a premises type unsafe condition with fusion like this, and like who are the lawyers, let's say in Ohio near Toledo, that have won the biggest results in the past. Then you could do a consult with one of those. So, I'm happy to do that if you'd like.
Mr. Frekhtman, I have another question for you. So going back to our lawyer demanding 1.8, and his economic report just came through a couple of days ago, and it was for 2.2, and that's just for his wages, his his lost wages of what, and that's up to 67 years old. So
Oh, the 2.2 was just for the wages. Okay, just for the wages. Okay.
that's just for the wages.
Right, because I was talking about, like, I mean, that's okay. So that's fine, because I was also talking about future medical costs. What you could also do is go back to the surgeon who did those surgeries, and speak to the, or you could use like a life care planner, and they would like itemize what these things cost, like future surgeries, because Jason segment disease, like future fusions, prescriptions, physical therapy,
Not even for
MRI,
not even
right?
for
So that could be another 2 million or 3 million or more. Like in my case, it was 2.7, and it was a 57-year-old, and it only had a one level fusion. So for a 52-year-old with like the C3 all the way to C7 plus the other surgery, it might be much higher. It might be like 4 or 5 million just in medical costs. So then those are also economic, because the medical costs are economic. And then of course the wages are economic. That's lost salary. But if you have both, then it makes the case even bigger, And even if they have, let's say they have like only a million, but if you have all this evidence and you show it to them, you say, look, all you have is a million, and I have like 4 million in medicals, I have 2.2 in wages, and then my pain and suffering is going to be worth at least a million for all of this, right? So then, look, I'm showing you, like, what is that, 5 plus 2, like 7, and all you have is one. So just give me the one, because if you don't, then I go to court and I get, let's say, more than one, like 3 or 4, who's going to pay it? Then you're exposing your policyholder, this OJW investments, right? Then they're going to lose their mall, because then they're going to be liable for this. Then they're underinsured, right? And the insurance company has to put their own financial interests on an equal footing with that of their policyholder. They're insured. They can't leave their insured out to dry and say, you know what, I'm just gonna, even though I've been getting premiums for my insured, I'm just gonna let them get hit with like a $7 or $10 million verdict, right? So that's kind of like a bad faith situation. And I'm not, you have to research bad faith law in Ohio, but that's something else you could pursue. But I would say, yeah, definitely you wanna go, you wanna find out that the full insurance, you wanna put pressure on them with like a settlement opportunity letter, or maybe this bad faith type situation where you go after them. Because it sounds. Do you know who the insurance company is? Which insurance company you're dealing with?
State Farm.
Oh, okay, State Farm.
So would it be so going back the 1.8 demand, and then the 2,200,000 in the economic report? We're me and my husband have discussed it, and we just feel like that demand needs to change. It needs to be raised.
Well, that's the other thing. Like, if this lawyer calls them up and says, "Well, now I'm changing my demand," they're gonna laugh at him. They're not gonna take him seriously. That's another reason why you may need to like speak with someone else, get a second opinion, because if someone new comes in, well, then there's no demand. The new lawyer is he's not, he or she is not bound by what a prior lawyer demanded. So the new lawyer could demand anything, demand a 50 million, but this guy, like, once he demands 1.8, if he says no, now it's like 4, they're going to say, well, wait a minute, you already asked for 1.8, we already wrote it up as 1.8. They won't take him seriously. You can't really, that's one of the reasons why I don't like demands. That's another reason why I don't like this whole demand, because once you make a demand, you could only go down. You could never go up, you know.
Correct. That's what I thought. That's what I wanted to talk to you about to see what the next move would be. So I guess what we're at the point where the demand was too low and we're not where we need to be as far as knowing if that's all the insurance. So what me and my husband talked about was maybe the demand changing that would kind of back them up against the wall to disclose more insurance.
Well, no, I mean, you don't have to change the demand to get them to disclose more insurance. Like, you're entitled to the full insurance information. You just has to maybe make a motion if they're not giving it to him voluntarily. I would just send them a letter and say, give me the primary policy, give me any excess, umbrella, concurrent, any other policies. Or if there's, get affidavits from the brokers, like affidavits of search, affidavits from the people who own this OJW investments, saying that we don't have any insurance other than this 1 million primary with State Farm. That's all we have. If you really have that and you're certain there is nothing else, okay, then that's what it is. But it's unlikely. It doesn't make sense to me. Like 20 units at a big strip mall, how could it only have a million? It's almost like impossible, because, what if, like I said, what if, unless they're relying on the insurance of each tenant to cover each tenant, but still, it sounds very, very unlikely. But I would just double check that. But then if the lawyer for whatever reason can't get that, then he just has to make a motion and the court will order it. So it's a pretty simple, it's like a one-page motion. It's not much you have to write or research to get something like that. Just the insurance. That's something you're entitled to like day one when you file a lawsuit. As soon as the other side appears in the case and answers your lawsuit, and you go for the preliminary conference, which is the very first meeting with the judge, it's right, like in New York, it's right in the pre-printed order. It's already pre-printed. Like, everyone gets that. So, it's automatic. You don't even have to
So
ask for it.
he should have gotten by now maybe an affidavit note signed by the broker. He said the broker.
Yeah, the broker, like an affidavit of search, an affidavit, because the broker is the one who like procures the insurance. They sell it or they get it, so they would know if there's only the primary or if there's any excess. Usually people don't use like multiple brokers on the same property, on the same piece of real estate, even if it's a big one like a commercial strip mall. So from the broker, from the owner, whoever's the owner of that LLC, the OJW Investments LLC, whoever the owner is, they should sign the. But like I said, like, you don't even have to do all that. The lawyer can just make a motion and the court will just order it, and then you'll have a court order. Then they have to comply with the court order and tell you the full information, and then you'll know if it's more than a million. Then you'll know how much it is, and then you can send them like a settlement opportunity letter for more. And if it's really only a million, then you might have a bad faith situation where you can say, look, pay me the million, and if you don't, then if I go to court, I might get like a $7 million verdict, and then who's going to pay? Then you're leaving this policyholder out to dry, right? They might get hit with more than their insurance. So then you get a quick tender. But yeah, it just sounds like very unlikely that's all the insurance they have on a big property like that, or commercial property.
So the lawyer is pretty much telling us it's kind of like he's training us to accept less than a million. He says they're not gonna. I can tell. I just don't see them paying a million, because my husband says if that's all they have, then they need to tender the entire policy for it. That's not even enough to cover. And he just keeps saying, I just don't see them doing that. And my husband is saying, look, I'm not gonna accept less than a million, or we can just go to trial. And he gets upset, and it just kind of seems like he's out for a quick payday.
Right, right. Well, that's the thing that I didn't like. That's what I didn't like, that what you told me is basically that. Well, it kind of goes hand in hand with this whole demand thing, right? Because if you're making a demand, it's like you're begging, you're asking them, hey, I'm demanding, please give me this money. You don't have to demand anything. I mean, you're the injury victim. They did this to you. You didn't ask for this. You're just driving your snowplow, you're doing your job. And then they caused this unsafe condition. They gave you a life changing forever injury. And then they're asking you to beg them for money, like, oh, please give me like $1 million or 1.8. And then they're going to say, we're not going to give you 1.8. We'll give you 200,000. And then you have to be like, oh, okay, I'll come down. I'll ask for 800. Okay, well, now we'll give you 350. Oh, no, I have to come down again, ask for 600. That's what they want you to do. They want you to keep coming down until you get down low enough that they're happy to just give you something like pennies on the dollar and walk away and say, oh, we made a good financial decision. We saved our money. Meanwhile, they make like, these State Farm makes like $92 billion a year, you know it's ridiculous.
Right.
It's really unfair. So that's why you need like a real trial lawyer to step in and say, look, this case is worth like 5 million. Pay it within 30 days. If you don't, that's fine. But then it's going to be 8. And if I spend more time preparing for trial, it's going to be 10. And if you don't have the insurance, well, then we're coming after this OJW. We're taking the strip mall. Then it'll be your strip mall. And then they're going to get scared and they're going to pay you. But you got to play hardball with them because
So, Mr. Freckman, I'm gonna send you over my email, and if you could send me the lawyers that you said, the trial lawyers that you know in our area that are good, would really appreciate that because we're gonna go back to this lawyer and we're gonna demand him to give an affidavit to the property owner and the broker to the insurance. And because I don't think he's went that far yet, which I don't see why he has not. And it's just not sitting right with us. And we just feel like there may be more. And then when we say that to him, he say that we're greedy. He's called us greedy.
how are you greedy? I mean, that's not even a lot of money. $1 million is not even a lot of money. You're entitled to way more than that. I mean, look, if the case with these kind of surgeries, if they have, like, for example, if they had 10 million, it might be worth like legitimately like 6 or 7 easily. Why would you be greedy? It sounds like this guy. I mean, like, I don't know why would he get mad if you're saying you want to go to trial. If he's a real trial lawyer, then that's his job. He goes to trial. Like, does a guy who sells fish, like a fishmonger at a seafood store, does he get mad if you order a fillet of salmon? No, because that's his job, right? He sells fish. Why would a trial lawyer get mad about going to trial? Like, if you tell me I'm going to trial, I'm like, yay, yippee. I get happy because that's what I want to do. I want to go pick a jury. I want to go give an opening statement. I love doing it. It's fun. If he's afraid of going to trial, if he gets mad at you and calls you greedy because you want to go to trial, he's probably not a trial lawyer. And that kind of goes with what I told you earlier because I did a search on him. He did have some results, but one was like a pretty okay number. Every other one was either 0 or like 7,000. One was like even like 3,000. Why would it? What kind of trial lawyer has those kind of results? That's kind of weird. So it sounds like he's maybe has the mentality of these defense lawyers, which isn't the best for you. You don't want someone like that representing you.
Correct. And that's why we called you because we just had all of these red flags. And this is our life, and our life has stopped. And this is it. Once my husband signs, on the dotted line, he can't go backwards. So we're just trying to make sure everything is all T's is crossed and all I's is dotted. We just want to go through this and make sure we're not leaving anything out.
Right, of course, of course. And what kind of so who did your husband work for before? Was he employed with like some kind of company or
We were self-employed. It was his company.
oh, he had his own company, just like he had like a snowplow company or just a snowplow business?
Correct. Yep. We did grass cut and snow removal.
Oh, I see. So then what happened with the bit was the business closed down afterwards?
Pretty much, yeah. Yeah. He's permanently disabled. So we had to pretty much just everything stopped. He's on disability now. And it's like I said, we're just trying to make sure this is done right because this is it. We can't, this is our livelihood, so we're trying to make sure that settlement is correct. And the way it's going, it just feels like we have a lawyer that's just not in for the fight.
Yeah, that's not good. That's not good. So, which firm is the lawyer with now?
So it's crazy too, Mr. Frekhtman, because let me see if I can go to it. So when he hired a firm out of Cleveland, Ohio called Jury Law is what the name of the firm
Okay,
was.
yeah, I think that's the one I searched this morning. That sounds familiar. Yeah, yeah, that sounds familiar. But he's not with them anymore. Is that right?
Oh, he's not with them anymore. And let me see. So next I knew he went to law firm is where he was partnering with and claimed that he was going into his own practice. But then, we got the new contract. We said that I thought was kind of like, oh boy.
Yeah, that's weird. And then where is he now? Is he still there or is he somewhere else now? I don't know. It's a little confusing, but I saw another lawyer with the same name, and I think I saw another firm.
Now he used to be a lawyer at Progressive Insurance.
Oh, okay, that makes sense then. So he used to do defense work, right? That's why he has this mentality of, defense, because it really sounded to me like he has a defense mentality. So maybe that's why, because he used to be a defense lawyer. So he has this mentality of like, oh, you guys are greedy and all these things. You should be happy with anything. That's kind of like what the insurance companies preach, and that they indoctrinate everybody with that. So if you kind of start with that and that's what you learn, it's kind of hard to get out of that mindset. So it's almost like a mindset. Once you learn that, you get indoctrinated with that, it's hard to then change. Some people can, but it's not easy.
Yeah, that's the questions that I have for you. And I just, like I said, me and my husband, once the kind of economic report came back and we seen the amount, and then it was already a red flag because he made a demand without our consent. We didn't even know.
Well, that's a big problem. That's almost like, that's not just he's doing what's best for you. But yeah, like, feel free, let me know. I'll send you that information. I'll give you a few people, or if you want, I could have one or two of the people reach out to you, or I could give you their number if you want to call them for a second opinion. But whatever you need, I'm here to help, any way I can. I'm happy to help.
Mr. Franklin, you don't take cases in Ohio.
No, I can't, because I'm only a New York lawyer. But like, if for example I find someone for you in Ohio and you're happy with them and they're like a good, well, if I recommend them, usually they'll be one of the top trial lawyers that's won many millions of dollars. And then if they want me to like come in, if the case does go to trial and help, I could do that. I could apply pro hac vice, get admitted in Ohio just for that case, and come over, and do the case with them. I can partner with them like that if you'd like me to, if they'd like me to. I've offered to do that. I've talked, so I'm allowed to do that. But
Okay. So what? Yeah, I'm gonna send you my email. I'm gonna text it to you, my email address, and you can send me over the names of some of lawyers that you recommend. And what I'm gonna do is we're gonna get with this lawyer and we're gonna see if he's willing to send a a affidavit to the insurance broker and to the property owner, and let's see if they mention anything as far as additional insurance that way. But we also want to ask him, could he file a motion to make them? Is that what you usually do, Mr. Franklin? You file?
Well, no, and like I said, in New York, I mean, you don't have to file a motion because it's automatic. They just tell you. Like, that was the only, like, that case I was giving you the example of with Chubb with the 25 million. It was just a few emails back and forth. But at first he was like, I'm not going to tell you. And then I was like, come on, really? Because it's this provision of the CPLR. We have the civil practice law and rules in this provision. And then he was like, okay, I'll just tell you. And then he sends it over that it's 25 million. So it was a little bit of pushback, just a few emails. But I've never really had to even file a motion. But I'm just saying, like, if you can't get the information voluntarily, then file a motion. The judge will definitely so order that and give you the court order saying that, mandating that they give you the insurance information, including the excess and the umbrella. And if they really don't have it, I would get affidavits of search, affidavits from the broker, everything you could possibly think of, just to kind of close off those potentials, those close off those
Right.
avenues, or those, that way, okay, I've done everything I can. There is nothing else. All it is a million. But it just sounds like very unlikely. It sounds very strange, but yeah, I would just really, I would like 100%
So
confirm.
why would Mr. Frekhtman, why would the defense attorney state, what is she saying when she says she's working on getting approval to respond to our demand? Now, she's not saying she's going to pay the demand. Is it just for her to start negotiations?
Right, exactly. So what she's doing is, she reports to the carrier. There's an adjuster at State Farm. So what she's essentially saying is that she's going to tell them that it's 1.8. She's going to do a write up and talk about liability, what happened, the damages, maybe the medical bills, etc., and then get some kind of an offer from the adjuster to then give you an offer against that. So like I was saying, a lot of the times they'll offer you like a third or even less than a third of what you demanded. So if you demand 1.8, they might offer you, what is the third, like 500,000, or maybe not even that, maybe like 400, 300,000. What stage is the case in right now? Have all depositions been done? Are you on the trial calendar? Do you have a trial date?
Yes. Yep, we're this is our second, actually this is our second trial date.
And
That's
and
another thing.
and when do you have when is the trial scheduled for?
January the 12th is the trial date.
Oh, January
This is
12th,
another thing.
2026?
26.
And is it final? Is it like a final trial date, or is it has it been marked final, or?
So what happened was, this is the actual second date. The lawyer kept asking for more time, more time. The defense kept asking for more time.
Yeah, they always do
And
that.
that was another thing. And I asked the lawyer if he we would be okay, because the judge had already gave her a 60-day extension to gather up records that she was waiting on for the IME. So they granted that. She comes back and she says she's still waiting on records. She did a continuance, and it knocked us off the trial calendar because the lawyer, it was unopposed. He didn't
Oh
oppose it,
no,
and
that's
we
really not good. Why would he unoppose that? That's crazy. So then you got knocked off. When was the first date? How long ago was it?
we would have been going to trial September next month if it wasn't knocked
Oh,
off.
September of 2025, and then he got it knocked off. Oh, okay. So then, but January, so that's only like what, October, November, December. It's only like 3, 4 months later. That's not too bad. Why? Because in New York, if you knock it off the calendar, I mean, the calendar in New York is like takes 3 years. So if you knocked it off, you'd be waiting another 2 years. So I was like, oh my God. But in Ohio, that's better. So, but still, you shouldn't get it knocked off the calendar. You should just, if they're asking for an adjournment, you have to oppose that. You have to explain they could have done it earlier, and then the judge will just give them a short date, like a few weeks or a month, 30 days, 45 days, not like 4 months. Now you're into next year, and you're not even sure they could come back, in January and ask for another adjournment. So yeah, it sounds like these guys aren't doing a very good job.
Mr. Frekhtman, a case like this, even though we're in Ohio and you're in New York, I feel that this lawyer made this demand going off of what insurance they told him that they had. That's what I really feel. I feel like he said 1.8 so they can work him down to the million, but I don't feel that he did it right, because should have made sure that what the limits were and what all insured was before he did that.
No, of course, of course. I mean, there's a lot of red flags. I mean, there's a lot of red flags here. I'm seeing like that's one that those are like the major ones, but I'm seeing like other red flags too. It just seems like the fact that he told you you're greedy and you shouldn't ask for so much, and that he's former defense lawyer and he has this record of like most of his cases are really low, like 3,000, 10,000, and then there's a lot of red flags. And yeah, well, why would you make a demand before even getting the economic report? That makes no sense, and not even knowing the insurance information, or not having it confirmed. Yeah, it's really, and then he's had sitting on like all these different law firms. It sounds like he's just into like maybe trying to make money. I mean, I don't know, but it just sounds like he's more into like starting new law firms, like this one, that one, making money, but not actually, doing what you need, what's best for the clients. That's not good either.
And yeah, that's exactly the way me and my husband feel. He's out to make a quick dollar and he's not looking for the best interest of my husband. Yeah.
Yeah, that's not good. Okay, so let me work on this. I'll get you somebody. I'll get you a few names of some really good trial attorneys. Then we could stay in touch. If you have any questions, just text me anytime. And if you want to do another call, I'm happy to do another call. Like whatever you need, I'll make myself available, and I'm happy to help.
Okay, Mr. Freshman, you have a good rest of your evening and thank you so much.
Thank you so much, Mr. Frekhtman. I will send you this.
Oh, thank you, and I wish you the best of health. I hope you feel better, you recover fully, and wishing you all the very best.
Wish you could have took the case because me and my wife follow you on YouTube, and man, we be like, we wish you was out here.
Oh no, but maybe I can if I can give you one of my partners, and then you want just you could just tell them, hey, I want Arkady to come in. I can come in if the case goes to trial. I can come and do it with them. I'll partner with them on it. I don't.
Sounds good. Sounds good. I'm gonna talk to my lawyer, and I'm gonna see if I can get him on the same page as me and my wife. But if I feel that his interest is not where ours is at, and we're not on the same page, I guess I'll be moving to another firm. I mean, it's like I'm bouncing around, but I was telling my wife, once this is all over with, this is what we're left with. We can't get a second do-over of fighting this case, and this is our life, our
Right,
livelihood.
exactly. You only have one chance at this. Yeah, right.
Right.
But yeah, that's why you have to get the maximum. You have to get full justice. And yeah, and don't worry about that. Like you're not really bouncing because you've always been with this lawyer from day one. So if you end up, just start off with a second opinion because you might also run into an issue of because the case is already going for trial in January. It's only a few months away. A new lawyer might be hesitant to step in because the first lawyer might be entitled to most of the legal fee, but you just do a consultation, see what do, maybe speak to one or two lawyers, see what they say, and hopefully but if there is more coverage, like if there's like let's say a million with a 5 million or a 10 million umbrella, then you may want to see if somebody you can get somebody else to step in because this guy's not even wanting to go to trial. He's not even opposing adjournments. He's telling you, getting mad at you when you say you want to go to trial. So you definitely want to get somebody who's more of a trial lawyer. That's really, really critical in a case like this.
Yes, yes, I agree.
Okay, Mr. Frekhtman, I'm going the email address to you and wait on you to respond.
Okay. Thank you so much. Thank you. Have a great night. Feel better. I'll talk to you very soon.
Okay, thank you.
Okay. Bye bye.